First and foremost, the permanent residents of the state of Jammu and Kashmir are citizens of India. Although Mr. Lord may sometimes behave that he's not, but in fact he is. Now I come to the question of legislative sovereignty is divided between the union and the state. On a look at Article 370, which is the governing article of the relationship between the union and the state. Matters in the concurrent and union list acceded to by the then Maharaja are within the realm of the center, the union. And broadly speaking, the other parts of the constitution are within the jurisdiction of the state.
But therefore, the sequitur of your argument would be that matters which do not form part of the instrument of accession in relation to which the union was given exclusive control, yes, the four matters.
Yes.
The legislative sovereignty would therefore continue to vest with the Jammu and Kashmir Legislative Assembly.
Subject to the power of the president to apply the provisions of the constitution under B 1 and 2, but with the concurrence or the consultation of the. So any provision, theoretically speaking, if those qualifications arise, if that concurrence or that consultation takes place, then the entire constitution can be applied to the state of Jammu and Kashmir under 371. 373 is distinct from 371 because it's at a one-stroke abrogation of the entire Article 370.
Therefore, Mr. Jethmalani, you therefore also necessarily accept that there is a concept, sovereignty has two connotations. Yes. One, external sovereignty,
yes,
which undoubtedly vests completely with the Union of India. Internal sovereignty, which is then distributed between the union and the states.
Yes, that's a patent look at that. Nobody can deny that. But the constitution envisages that from time to time, further and further, and that's been as has been pointed out repeatedly during the course of these arguments, that with the passage of time from 1950 onwards, more and more provisions of the constitution have been made applicable. And some of them are those which were not originally applicable to the legislative or within the legislative jurisdiction of the center. But ultimate legal sovereignty rests with the union. And though that is Article 373. Article 370, sub-Article 3, is indicative of the fact that ultimate legal sovereignty, in the sense that you can get rid of the tunnel altogether that connects the union with the state legally and constitutionally. And 373 is key, is one of the key issues in this entire discussion. It's in all these arguments, 373, and the reading of the proviso, the effect of the proviso. That establishes most of the issues that arise in this case, at least it sets a platform whereby the others can be. Absent that, there would be nothing else, which is why the other side is at pains to point out that after the Constituent Assembly dissolved or became extinct, 373 has no application. In other words, the substantive part of 373 is now swallowed by the proviso. The absence of the Constituent Assembly and the power of recommendation which was vested in it now disappear. That's their case. Now, on that proviso, I'll have something to say. But this is the sovereignty issue. Now, there's also Article 147, which is some indication of legal sovereignty of the state of Jammu and Kashmir. That's the amending part. That is an acknowledgement. The third part of C, clause C of 147, is an acknowledgement by the state of Jammu and Kashmir that they cannot touch the Constitution of India as applicable to the state of Jammu and Kashmir. Now, the issue of Article 373 and the proviso thereto, it actually dovetails into three questions which I'll just frame, which are at the heart of the controversy here. The first is Article 370 temporary or permanent? Did the extinction of the Constituent Assembly of Jammu and Kashmir, referred to in the proviso to that article, render entire Article 373 oshos? And third, was the amendment by CO 272, to Article 367, by the addition of clause 4D, that article which made Constituent Assembly read as Legislative Assembly. Was that constitutionally valid? Now, my lord, as far as the temporary and permanent part is concerned, two issues have already been discussed. One is Article 370 is a provision that is a part of Chapter 21 of the Constitution of India, which deals with temporary provisions.
Yes.
Lordships have already noted that. Second is the title of the article, which describes its provisions as temporary provisions with respect to the state of Jammu and Kashmir. And well, third, the effect of the proviso requiring the prior necessary recommendation of the Constituent Assembly of Jammu and Kashmir before the President can act under 373(1).
So your contention is that the Constituent Assembly of Jammu and Kashmir was necessarily limited in point of time and purpose.
But I'll tell
Time, the framing of the constitution for the state, purpose, once that purpose was over, it had to come to an end. That's your submission.
and one of the proviso that it is a principle of construction that unless clearly indicated, a proviso would not take away substantive rights or powers conferred by a section or a subsection. Now that's Madhu Gopal's case. Now, not just a look at 373, and then I take you to my submissions on this most important point. Now, the Constitution and its provisions have to be looked at the perspective of people drafting it in 1950. Well, in 1950, when they did not know who the ultimate constituent power would be in Jammu and Kashmir. Essentially, what was 370? 373, which talked about the article ceasing to be operative altogether, because it was the terminus of the entire article. That article required the constituent power on behalf of the Union, acting on the one hand, which is the President of India, qua 370 and Article 3, qua Jammu and Kashmir through Article 370, he was acting as a constituent power. And on the other hand, the constituent power for the state of Jammu and Kashmir at that time was the Constituent Assembly. All documents from 1948 to 1950, all constitutional documents indicate that a Constituent Assembly for the purpose of framing a constitution was necessary, and that was the way forward, which is why Article 373 referred to the Constituent Assembly. But that didn't mean that once the Constituent Assembly completed its task, which was the task of framing the Constitution, that Article 373 would have no meaning, it would be ocious. Now, on the contrary, the COs issued from 1948 onwards, and now this is important, indicate two things. I'll just take a lordship very quickly through those COs now.
What do they indicate?
Yes. First, they indicate expressly that the Constituent Assembly and the Legislative Assembly, insofar as it applies to Constitution of India, are synonymous. In other words,
come again. The Constituent Assembly
and the Legislative Assembly are synonymous. I'll point out that expressly.
Where do you get that from?
From the various orders right up to 58, that they are to be read as the same, and to each such elected member shall be deemed to include respectively a reference to the members of the Constituent Assembly of the state.
Because there was no Legislative Assembly at all.
No Legislative Assembly. So I'll show you. There was no, absolutely right. There was no Legislative Assembly at that time. But even when there was, so look, that's the whole point. The point is, it was deemed to be a Legislative Assembly for the purpose of our Constitution. Why was this necessary? In 55, they were trying to get members of the Legislative Assembly of Jammu and Kashmir. Now, in CO 48, which is the next one, I'm running through it now, and this was in 1954. The date of CO 48 is 15th May 1954.
Okay.
Now, in this CO, for the first time, previously it was done for the first time, Article 367 was amended as applicable to J&K.
How is it relevant for your argument that Constituent Assembly means Legislative Assembly?
Because that's what the Union of India has done. They've amended 367.
It's clause D.
Yes. That's CO 272, which is under challenge. The same procedure was undertaken in 1954. For the first time this was done.
This was also pointed out to us by, I think, the learned solicitor.
In fact, that's in his list of days. It's the first exercise of 367 power.
But it was even, yes. But even earlier, they were synonymous. The Legislative Assembly and the Constituent Assembly. It emanated from 1948.
This 14th of May 1954.
Yes, the 15th of May 1950.
Right, when there's no Legislative Assembly in Jammu and Kashmir.
No, it's not. But now an amendment is made that they will be the same, even when there's no Legislative Assembly. And now we are not talking about for the purpose of a presidential election. This is now for every purpose. Your Lordship, I just see a provision in the Constitution of Jammu and Kashmir, 85(2). My Lord, substantively and in matters of procedure, the Constituent Assembly and the Legislative Assembly. In fact, what emanates from all this is that the Constitution...
But Mr. Jethmalani,
yes,
the fact still remains that after the Constitution of Jammu and Kashmir was framed
yes,
on 26th of January 1957,
yes,
Article 367 4D was again amended.
Yeah.
So delete clause D.
yes. But my Lord, that...
So that equivalence between the Constituent Assembly and the Legislative Assembly ceases the moment the Constitution of Jammu and Kashmir is framed.
Lordship is absolutely right. And I'm coming to that last one in 58. That's the last piece. But my Lord, what happened is...
That you will find at your volume 3, page 25.
Yes, Your Lordship is at page 25. The point is, all this shows that the Legislative Assembly... And why was this deleted? This was deleted because after the dissolution or the extinction of the Constituent Assembly, the constituent power in Jammu and Kashmir was now the Legislative Assembly. Power of amendment, in Article 368, it's in virtue of its being a constituent power that Parliament can amend. This is also recognized by at least 3 judgments in Indira Nehru's case with Raj Narayan. I go back to the beginning of what I said, right at the outset, that the idea was that 373 being the final step, after which Article 370 altogether ceased to exist.
The only distinction is that a legislature which exercises the power of amendment is not a constituent assembly. It's exercising a constituent power.
I agree it is. But otherwise, the alternative interpretation would be that abrogation ceases to exist. You can never abrogate Article 370.